Good evening, everyone. 7 o'clock. Call to order the July 14th meeting of the East Lyme Planning Commission. Roll call. Oh, we are missing one, and Kevin, would you please be seated as the alternate? Missing Tom Fitting. Thank you, Kevin.
Yep.
So we'll do roll call.
Kevin Mills.
Nick Menapace.
Brian Bombeck.
Tim Laducer.
Rich Gordon.
Nina Franco.
Alrighty. We'll do the Pledge of Allegiance. Okay. All right. Gary, do we have any additions to the agenda tonight?
To the agenda?
Alrighty. Call for public delegations. Public delegations is the time when members of the public are invited to speak to the commission about certain matters, items, referrals, or applications subject to a decision by the commission. A public hearing or in litigation may not be discussed. During delegations, the members of the commission will not directly answer questions or make comment. Anybody wish to, sir? You just state your name, please.
Good evening. My name is Donald Danella. I reside at 24 Patagonia Drive, East Lyme. I'm both an appointed member of the East Lyme Commission for the Conservation of Natural Resources and a member of the Board of Directors of the Patagonia Lake Association, or PLA. I will provide a written copy of my statement with this Commission's recording secretary following my presentation. The issue about which I am speaking tonight is a topic that I previously brought before the East Lyme Inland Wetlands Agency, or IWA, under their public delegations at their meetings this past March 3rd and June 2nd. I expressed concerns that the PLA had about an ongoing clear cutting and other site work on the 3-lot Lakeside Point subdivision, Assessor's Map 35.0, located on the northwestern shore of Patagonia Lake off Heritage Road. This commission unanimously approved this subdivision at your April 8th, 2025 meeting. I present to you the following information, which may be found on page 3 of your April 8th, 2025 minutes. Quote, Jeffrey Torrance, 197 Upper Patagonia Road, assisted the East Lyme Land Trust on open space projects, worked with DEEP in writing grants, and I emphasize, noted land trust space along the lake is for preservation purposes, distributed a conservation easement, attachment I, addressing lake access, end quote. I've attached to my written remarks a copy of this easement that was previously presented to your commission. As a document submitted in support of a subdivision application, I believe it was something that you must have considered in rendering your decision of approval. These two sentences in the minutes lack context, so I reviewed the video of this meeting several times. At approximately 1 hour, 26 minutes into the recording, I observed Mr. Torrance's testimony in which he states several times that the 3 individual homeowners would each be allowed to construct and use only a 10-foot wide pathway to the Patagonia Lake shoreline, which, and I emphasize, quote, will require a permit from the East Lyme Inland Wetlands Agency, end quote. This requirement was presented in red text in paragraph F on page 3 of this conservation easement, indicating its importance. Mr. Torrance specifically stated that this was among the provisions he negotiated with the Connecticut Department of Energy and Environmental Protection on behalf of the East Lyme Land Trust regarding this property. I note that there were no questions from the commission members about this conservation easement document or its intent, as you focused mostly on issues involving the property driveway, public access, and bonding before unanimously voting to approve. Later, when the PLA reviewed the submitted conservation easement document, we found a puzzling exception regarding the removal of shrubs and trees in its paragraph E. Quote, hand cutting and removal of brush, mountain laurel, and similar vegetation and trees with 6 inches or less caliper, provided no stump removal shall occur, end quote. Nonetheless, we are confident that in an upcoming meeting, the IWA would specifically permit and enforce a 10-foot restriction for pathway clearings, which would allow homeowner lake access, as mentioned by Mr. Torrance and specifically stated elsewhere within the conservation easement. The subdivision applicants, Portside Holdings Incorporated and English Harbor Capital Partners, LLC, subsequently sold this property to a builder, Mr. Rich Lemieux / Nova Developers, LLC. Unfortunately, during the spring, his personnel clear-cut all but the largest trees on the conservation easement parcels. As I previously mentioned, I brought this matter up before the IWA. At my appearances, I pointed out that this housing development had proceeded without any formal reviews and severely impacted what was proclaimed to be a conservation easement area. Agency members also expressed their concern over the lack of oversight with respect to this development at their meetings. As clear-cutting and other work continued on the site, I and another PLA member remained in touch with Mr. Gaishel, who you know serves as both the Director of Planning and Inland Wetlands Agent. I also contacted the head of the East Lyme Land Trust, which holds a conservation easement along the lakefront. He told me he was not concerned about the clearing in what was supposedly a natural area. Unfortunately, at the latest July 7th IWA meeting, Mr. Gaishel reported that despite the concerns of the public and IWA members, he could not issue any notice of violation or undertake any other remedies regarding the clear cutting along the lakefront. This was for 2 reasons. One was an apparent misunderstanding in a conversation held on a site between him and Mr. Lemieux about what and where clearing would occur. A he said situation about which I know nothing of the legalities. However, more damning was a small note on the site plan submitted to your commission, wherein on each of the 3 house plots the following text is found. Quote, 1, this plan refers to the subdivision prepared for Portside Holdings, Inc. and English Harbor Capital Partners, LLC, prepared by Gerwick Marine, LLC, and May Engineering, LLC. Scale 1 inch equals 40 feet, dated January 2025, revised March 31st, 2025. And 2, all brush clearing and conservation easement, CE, area shall conform to Section 7E of the Conservation Easement Documentation, end quote. Note that this is the allowance in the conservation easement allowing for the cutting of trees and shrubs that I previously mentioned. The present owner and his attorney asserted to Mr. Gaishel that this small note found on very detailed and busy plots submitted to this commission, along with a plethora of other materials, allow for the clearing that took place within the regulated 300-foot IWA inland upland review area, not to mention the so-called conservation easement. Not wishing for the town to be subject to a potential lawsuit if any actions were taken by the IWA, Mr. Gaishel conceded to the agency that Nova Construction was not in violation of its inland wetlands permit. Thus, this matter of wholesale clearing of vegetation is unfortunately over without any recourse. What are the lessons here? I find it outrageous that documents and statements made when seeking the Town Regulatory Commission approval for subdivision development can be willingly ignored or gotten around by using a not-so-obvious subterfuge. To me, the provisions written in the conservation easement and on the site plans were obviously purposeful and allow for the destruction of vegetation in a supposed conservation easement area. The testimony and statements that the homeowners will be limited to a 10-foot clearance for lake access as approved by the IWA were deceiving at best. This situation is a warning to this commission, which provides a vital service to the town of East Lyme with respect to development. It should behoove both town staff and commissioners to carefully scrutinize all details of the materials submitted to you, ask pertinent questions about any matters that are unclear, and either disapprove poorly constructed submissions or impose the necessary conditions to make a development conform to what is best for this town, its citizens, and the environment. Certainly, these caveats should apply equally among all submissions to this commission. However, I am also advising you to carefully consider the track records of certain entities that come before you, and perhaps be more considerate of these during your deliberations and approvals. The last straw about this whole matter is one that I recently learned about. Because of the narrow lakeside easement granted to the land trust, these homes apparently cannot be taxed by the town as waterfront properties, which is another consequence of this application, whether intended or not. I note that the Conservation Commission, upon which I sit, is presently examining open space issues within the town. There are other examples of open space and conservation easements that are either problematical or have not served the purposes for which they were first proposed. I bitterly regret not having heard about the Lakeside Point development scheduled for your April 2025 meeting. I would have strived for a public hearing to be held. I'll never know what issues I might have brought forth then, but the obvious inconsistencies in a conservation easement certainly might have been a red flag to take notice of. As I recently said to the chair of the IWA, I and other members of the East Lyme Conservation Commission, a non-regulatory but advisory body, will be happy to review or assist any town commission in any way we can, particularly when the matter relates to environmental and natural resource issues. Finally, I've attached several photographs to my written statement so you can appreciate what I call the unregulated damage done to the shoreline vegetation of Patagonia Lake. Hopefully, any adverse effects to the lake, which is part of the town's public water supply aquifer and a significant place for public recreation, will be minimal. Thank you for the opportunity to speak this evening.
Thank you.
Thank you. So do we have your contact information in there in case we want to take you up on the offer to?
No, but I can provide that to Mr. Gaishel.
Okay. Thank you.
Is Mike's on? Very light. Can you all hear us okay? Okay. It's very light.
All right, so the next up is reports, communications. I don't know if we have any communication.
I didn't receive any this month.
Okay, zoning liaison, last month, did anybody go? I don't,
Who the liaison is.
I forgot to see whose turn it was. Okay, no one's reporting. Okay, we'll skip that. Ex officio, you good? All right. Gary, you got anything?
I could speak a little bit to the zoning meeting.
Sure.
Just very briefly.
Yeah.
They're discussing an 830G moratorium. They're going to have a public hearing. They're discussing a data center moratorium. And they also might create a subcommittee to change a mixed-use zone into residential down by Black Lake. They also are trying to get the metal fence replaced on the Amtrak, which is an ongoing thing for a few years now. And that's about it.
Thanks, Kevin.
Thank you, Kevin.
Yep.
Gary, planning director, do you have any reports?
Nothing to report at this time, other than we're making just slow progress with the housing growth plan and working with COG to move that ball forward.
Okay.
I think
As far as subcommittees, we're still working on standing up the affordable housing team.
yes, I think so.
Okay.
I think because our approach will be maybe a little different based on the estimated costs if we do it in-house versus using the COG. We may not need so much participation from so many groups, but because the COG will be doing most of the lifting.
So we did a, did
But I
we,
think right now, we've got I think Nancy Kalal from zoning is interested, Norm Peck, I know yourself, Tim, Nick.
okay,
So I think I'd like to get someone from water and sewer involved in that. I think that'd be pertinent to have them on there. So I'll confer with Ben and see if we can't find someone who's from the Water Sewer Commission to join us.
okay,
And at least I think with that, at a minimum, that would give us a good basis to work with the COG and get them the information they need.
excellent. From chairman, I don't have anything to report tonight. So that leads us to approval of last month's minutes. Does anybody have any comments?
There's just some typos with the names in the top.
Thank you, Rich. I'm trying to remember.
but I didn't see anything of the content.
Okay.
So,
Gary, do you understand what the typos are? I'm not sure. We can let you know that after, or,
But you would go through them now because these
Okay.
will all get incorporated into this meeting's minutes
sure.
as changes to the
okay.
previous minutes.
I have it here because I noticed that.
Last month's
I'm just trying
meeting's
to get,
approved?
okay.
Looking at first off.
To June 9th?
June 9th, yeah.
June 9th minutes, right?
Delegation,
There,
chairman,
Oh, just under section 1,
yeah.
my last name spelt wrong. Brian's last name spelt wrong.
Brian, Nick, yeah. Oh, might have been corrected, I think.
Yeah, that was really,
Oh, under the roll call and pledge of
Yeah.
allegiance.
Yeah, and the other one was simply that we did not approve May's minutes because we didn't have them. So I don't
Right.
know if that.
Oh, that's right.
You know,
we still need to approve May's minutes then.
Mm-hmm.
Yeah. Do we know the status of that, Gary?
The May minutes, I can,
May?
Yeah, I know, being that we don't currently have a recording secretary, I know that's.
Yeah,
been a
there's,
little-
I will have to get them done.
yeah, nothing
We'll
up
get
there
that from the
at
transcription.
this time.
Right.
So,
Okay,
yeah, we can use the YouTube transcription to create the minutes.
all right.
So
So
we'll
that's helpful.
delay approval of May and June till next meeting? Is that what we're gonna do?
Sure. we can
Okay.
do it.
The only other thing I noted is it does list our recording secretary in there, although they were not in attendance. I don't know just if they were still technically the recording secretary, even though they weren't here.
Okay. So that leads us to public hearings. Tonight we have application of Kristen Clark, PE, PTOE, applicant Duval Partners LLC owner. Application for a 20-lot subdivision of approximately 12.67 acres of land zoned RU 80 on property located on the south side of Holmes Road between 20 and 38 Holmes Road, East Lyme, Connecticut. Assessors map number 57, lot 30. Date of receipt of application is 6/8/26. Public hearing scheduled for tonight. Mr. Garrity, you're up, sir.
Thank you. Paul Garrity on behalf of the applicant, members of the commission. I want to indicate tonight that we just received at about 5 o'clock this afternoon comments from Mr. Gaishel on the application. In addition, on Friday at 5:02, I received an email from Ledgelight Health District's Chief of Sanitation indicating that despite a prior approval of 10 of the lots in here for well and septic, they had issues with that, but failed to identify them. At about 5 or 4:48 this afternoon, I got a response to that letter indicating what their issues were. I haven't had a chance to review that yet, nor has our professional staff. So what I'm going to request of this commission, and it's contained in my July 9th letter, where I indicated we would like to have the staff reports prior to this so that if there are changes or responses that are needed, we could do that tonight and present the full presentation. But because we just got those and my professional staff hasn't had a chance to review it, I'm going to ask that the hearing be open tonight, but no testimony be taken, neither from the applicant or the general public with regard to this, since the Robert's Rules orders provide that we go first, then public comment, and then a chance of the applicant to rebut. And I think it's only fair both to the applicant and to the public that they get a chance to see exactly what's in the file, which leads me to the next issue. When I looked at the website today for the application, 10 of the documents that we had previously submitted are not listed as in the file or on the, I have a list of those here, which we'd ask be made part of the public record for this so that the public can see what our response has been to this. But I also understand from the memo that Mr. Gaishel emailed me this afternoon that there's a jurisdictional issue relative to notice to budding towns, and that time frame has yet to expire. Because I'm concerned about that being grounds for an appeal by anybody, including the municipality or the general public, I'm going to ask that we continue this to the August hearing before we start taking any evidence, so that that time period can expire and give the adjoining municipalities the opportunity to comment if they so choose on that. I think that, frankly, is it for what I wanted to say tonight. I make part of, and ask to be made part of the record, my July 9th letter of 2026, along with the June 9th letter of 2026. That was, as this commission knows, based on Ledge Light's reviewing this, and we met face to face with them on a number of occasions. 10 of the lots, they wanted some additional testing. Because of the statutory requirement for when that testing has to occur, we started it, but we can't complete it because we didn't agree to do that with Ledge Light until sometime in early April. And under the statute, you have to start the testing in February, and it has to continue until June. So the lots 1 through 10 were removed, and on June 9th, we submitted a revised application for lots 11 through 10. And therefore, I think it would be premature to start taking any evidence from the applicant tonight relative to this application in order that we have the opportunity to respond to Ledge Light, respond to Mr. Gaishel's comments on that. We did get one, Mr. Close did respond in terms of his review of the application, and he was looking for one particular document, which I forwarded to him previously, and was also in the application, but I sent it to him again when I got the email that he was looking for that document. So I'd ask that the commission open the hearing and continue it. The other item I would point out, too, is I think in the agenda, which I'm looking for right now, it indicated that the acceptance of the application was on June 9th by this commission, which, if that is the case, then that would give the commission 65 days from that date, or from the last date, to complete and conduct the hearing, which makes the August date workable.
What's this right here?
That's the, it says right.
So Gary, I'm confused.
Right, yeah, the 65 days would start from there,
Yeah,
and we should be able to hold a public hearing,
right.
right?
So I actually think if it's 65 days to start the public hearing from that date, then there's more time. We could actually go into September if need be.
So
But I'm hoping to do this in one night, since,
Well, having already noticed this evening,
right. I think tonight,
would be that you would naturally.
Gary, can you
Yeah.
open up the application there? It's like the sixth one down. So what does that say in the upper right hand? It was received on May 11th.
May 11th,
So that's the submittal date of the application. Where are we getting June?
May,
yeah, I don't know where that came from, but I think if we utilize the June date for the receipt, then we have adequate time to continue this to August. And
So the application of record says May 11th.
Right. And it was received May 12th at that point in time, and then scheduled in June for a public hearing. On June 9th, it was scheduled for a public hearing. So I don't know whether that's a Scrivener's error.
I thought May 12th was the night of our last meeting. That would start the clock, wouldn't it? May 12th.
No, you would have 65 days from that date to commence the public hearing.
From May 12th,
Right.
right.
So
So
we're-
that's June, July, that's
Yeah,
tonight.
we're well within the time frame.
Yeah, we're in like day 58 tonight of
Yeah.
the 65-day clock.
Correct.
And you're requesting to extend it, which you're allowed to do.
Correct.
Okay, but I'm not sure where we get the June submittal date on. So tonight, you don't want the public to be able to,
Right. As I said when we had a brief conversation, the public is not going to see what we're ultimately presenting because we haven't had a chance to respond to staff comments. So rather than take comment from the public tonight, which would only typically be done under Robert's rules after we did our presentation, let's wait till we do our presentation and have addressed those staff comments. hence the reason for my earlier letter saying we need to have them by a certain date so that we can respond, and then everybody coming to this meeting will have a chance to speak. But because we didn't get those in time, I'm requesting that we open the public hearing in order to start the clock for the public hearing itself, but continue continue it until August in order to take testimony.
You're not prepared to respond now, so then they can respond since they're already here?
The problem, no, because I had a chance to take a cursory look at Gary's memo in there, but they require technical expertise on this, which I don't have. They would require us to then say, okay, if the public seeing that memo raises questions, we're going to say, well, we're going to take care of all that, but we haven't done it yet. So let's take care of those things in the memo. Then the public can look at what we've done, can look at Gary's response to that, see if it's acceptable to them. But we'd basically be talking about something that's not going to ultimately be before this commission in terms of what the design is. I mean, there's not going to be significant changes or anything to it, obviously, but there are issues in there relative to the road distance. I saw in there.
If they're not too significant, I'd say we go forward with it.
I'm going to just object to that. I don't think you can do that.
Well, if you said they're not significant.
Well, I haven't had a chance to look at all of them. The ones I did see weren't necessarily significant, and the one most importantly was the fact that, and it's not the applicant's responsibility, is the notification to adjoining municipalities. That wasn't, the adjoining municipalities were not giving enough time under the statute to respond, so they would have a right to object. So that the applicant's being put in a position where appeals are, or grounds for appeal are being created by going forward tonight.
I understand. A lot of people are here and they.
I understand, but that is not the applicant's fault. That is not the applicant's
That's no one's fault. It's a good thing.
Yeah, no, I agree. I mean, they won't be the only one coming back. We're coming back too.
I guess in terms of the referral, the reason it didn't hit the 35 days is because the application indicated that the site was less than 500, it was more than 500 feet from the town boundary. Based on my review of the application, when I looked on the GIS, I got 468. So that referral went out later than it would have typically had the application had identified it at 500. We would have already automatically, just from day one, referred it over to Montville and the COG. So that explains why that referral is kind of pending.
Okay.
So you said it's not the applicant's fault. On the application, you say, are we within 500 feet of a town boundary? You said no.
We don't think we are, but that's a disputed issue right now, apparently.
So,
Okay.
yeah.
Mr. Chair, is there any way that we can just simply ask that, like, we can ask, it's going to sound silly, but I assume that the issue here is you're feeling that that the public would not be fully informed about the project that they're commenting on. Are you concerned that that would bias us or something, or?
Perhaps, but I'm also adverse to being put into a position where I have a memo that I've just seen that I have to either defend or say, this is how we're going to resolve this is how we're going to resolve that. When I frankly don't know personally, because that's going to be to my surveyor over the issue of the distance to Montville. Engineering issues are going to be either the surveyors or the engineers to respond to.
Yeah.
So, I just think that it creates all sorts of grounds for an appeal, both for the applicant, for the public, and the safest and best way to proceed on this is to allow us to address the comments from staff and present it then, so that, and the public should be able to see what our response is in advance of that, because we'll have responses before the next hearing. So that when they come in, they're asking questions that pertain to the application we're actually seeking to have approved.
All right, so Mr. Chair, I guess what I am concerned about is that if this is the desire from it, then we may unfortunately be asking the public to inadvertently give more grounds for an appeal. Is there any way that we can simply, ask those to, essentially the next time they come in to just, they don't have to respond to the individual comments that they're made tonight, and then they can just respond to them the next time? I know that's kind of repetitive, but at the same time, I do not want to tell people that they can't talk tonight, because a lot of people came out to speak about this.
There's more issues than just not letting the people speak, I think, with this whole
The
thing,
issue
you know,
here
it's-
would be whether or not our rights have been, truncated here, because the process is the applicants go first, then the public gets to speak, and the applicant gets to rebut. And without having my professionals here, and my professionals having the opportunity to have looked at what the staff comments are, Ledge comments are, we're going to get comments from the public that may be off point, that may be incorrect, or that may be relying upon things, that, for instance, there's some language in there about the solar having did we determine, for purposes of solar energy, the location of these lots? That's in the design report, but in the comments, it says it wasn't done. It's in the report. So there are all these things that we're going to be scrambling to respond to with the public tonight. When we can respond to them in writing, public can look at what our response is and any changes that we make, and then comment on that when we get to the August hearing. I think procedurally, you're handing me a grounds for an appeal. I don't know why you do that, frankly. Not that I want to work against myself, but I want to make this thing as efficient and as straightforward as possible. And I think we are going to create some confusion here, because once the public hearing is closed, if people bring up comments from the public that weren't relevant because things have been addressed, that creates a huge problem from the standpoint of an applicant sitting here going, well, wait a minute, you just considered a bunch of different things that you shouldn't have considered.
So Gary, how do we handle this application that we have in place now that's inaccurate?
I don't think it's inaccurate. It's been revised based on the meetings with Ledge to reduce the size of it. But it's not necessarily inaccurate. It references the correct property. It references what we're proposing to do. We've just halved the size of it because Ledge is saying this testing has to occur between February and June, and we can't get that done, obviously, given where we are in the calendar.
So the application is for a proposed subdivision of 20 lots. And that's what the application says, and you're...
Right, but there was a modified application submitted on June 9th, and that was one of the letters I just gave Mr. Gaishel, and that doesn't...
That didn't get up there yet? Is
It's
that...
not up on the
Okay, so
website.
this has changed?
That's changed, correct.
Okay.
So that form is literally changed.
Well, it's gone from 20 lots to 10, yes. I don't think there's much else on the form that is impacted by that, just the size of the development.
So this
Is that the
physical
June
form-
9th?
I guess just for clarity,
Oh.
the physical form has not been altered,
Correct.
changed. When you say that the application is changed, you're just saying you've reduced the proposal from 20 lots to 10.
Correct.
Okay.
Is that
So-
legitimate?
So in keeping with the legal notice, which advertised 20 lots, yes, it's less than the 20 lots, so you can reduce it. I think it's worth noting, the discrepancies that we've identified on the application as a whole, such as the 500-foot distance to the neighboring municipality. Things like, okay, yes, the original proposal was for 20 lots, but the rest of this information is correct, with the exception of the town boundary. Again, they say no, so again, that might be a surveyor, requiring a surveyor to determine the actual distance.
So, the road names are wrong?
And these road names indicate Nehantic Highlands and East Nehantic Drive, West Nehantic Drive. I think the subdivision name is correct, Nehantic Highlands. However, the plans, they chose a road name of Danielle Way. The name was? So
Danielle's Way.
Danielle's Way.
So-
So I would,
What's the protocol? Someone submits an application, and they write things on here like, I want a 20-lot subdivision, and then they come back and say, oh, no, it's going to be 10. And some of these other information is wrong. They can just
so they.
rip this up and give you a new one?
No, that's all part of the record.
Yeah.
But they would, as typically what's happened in the past, is like Mr. Garrity does, he submits a letter saying, we're going to revise the proposal. These are the changes that we're making. We don't actually get a new form, we typically don't.
Yeah, but you got fees and everything tied to this form, right?
Correct. Application fees that have been collected.
So wouldn't that be a basis to withdraw the application and resubmit?
In that we've collected a fee,
No, and just the information on the application is incorrect.
it's not
You're
consistent with
changing
the,
direction.
not consistent with the revised. Then I mean, that's you could, I don't know, how strong of a basis that is for
I mean, it's just, I don't know, what does everybody else think?
If I may just address that, Mr. Chair, it's not uncommon for any subdivision application to end up smaller than what's submitted, because commissions say this lot's not acceptable or whatever. And all we've done, and the application for the remaining 10 lots is virtually no different than what was included in the original package. Where you're going to see changes is in stormwater management, impervious surfaces, things like that, because they've all been reduced by half at this point in time. So there have been amended design reports submitted with this, but the issue becomes, was that original notice sufficient to apprise the public of the location and the nature of the application? And it clearly was, evidenced by the number of members from the public here. But as long as it doesn't exceed that, it can be reduced during the application process. And that's essentially what we're doing in light of comments from Ledgelight saying we need more testing on half of this parcel in order to review the septic designs on there. And that testing, unfortunately, as I said, can't occur at this point in the year. It has to occur between February and June.
So I found a number of inaccuracies in this application. You know, I just think at this point we have an incomplete application. We're in the public hearing phase of this. We have the public here that wants to comment. They need a complete application that's accurate. You're proposing to delay the public hearing another month so you can clean up this application. Is that what you're saying?
Well, certainly to address the comments from staff on this. But in terms of the inaccuracies, I'm not sure whether you're referring to anything specific or you're referring to Mr. Gaishel's memo, where he's raised a number of issues, which we will do our best to address. But in terms of the public notice, there's nothing materially inaccurate in the public notice that would cause this thing to be subject to having jurisdictional problems.
Gary,
Yes.
your June 8th memo to the commission, and you have your findings there, and at the very end of that, you said you recommend the commission to find the above referenced application incomplete and offer the applicant the opportunity to withdraw before taking the vote.
Correct.
Incomplete because of the 20 to 10?
At the time, it was mainly because of the lack of certification from the Ledgelight Health District, which at that meeting, we discussed that comment, which I had to redact because they were able to submit their application, make progress with the health district, and I think at that time, they had 10 lots that were
Approved.
already, that the health district suitable. So I had to redact that comment. I did provide you an updated memo this evening. And in that, yes, I did find a number of, whether you want to call them deficiencies, or I had a number of comments, although being that the public hearing is opened and they'd have time to actually update and revise their plans. And my conclusion there was they would have 30 days which to do that. And I'm recommending that the applicant revise the application materials to address the deficiencies so the commission has sufficient record to determine whether the proposed subdivision as modified adequately protects public health, safety, drainage, environmental resources, access, utility service, and long-term affordability, and whether any reasonable modifications or conditions are warranted. So that was my recommendation based on kind of where we are, my brief discussions with Attorney Mike Carey, who's on retainer for this if we need him. So I would,
Thank you.
I think in terms of jeopardizing the procedural process and risking an appeal based on, just procedural matters, I think if we can avoid that, that's a little more advantageous, and if you're gonna have to deal with an appeal, it should be more of a, in my opinion, a substantive nature, so you can look more on the merits of the application. So I'm thinking procedurally, we just continue as been requested by the attorney, whether or not you take public comment, in terms of the rules of, Robert's Rules of Order. Attorney Gary has highlighted that, again, that's up to you whether you follow them. Again, the Robert's Rules, and no one said they're statutorily required, so it's, you have bylaws that kind of dictate how you run your meetings, so that's.
Okay, so we're looking for a motion to defer public
Just to
hearing another month,
Just to continue the public hearing.
continue it another month.
Right, you did open the public hearing, correct?
Yes.
Yeah.
Yeah, well,
Yeah.
I'm standing here, so,
Yeah.
yeah.
Yep. So do I have a motion to continue the public hearing until August, whatever the next meeting is?
So moved.
Second? Anybody second?
August 11th. Second, need nine?
Okay, nine, all right. Take a vote. All those in favor? Aye. 6-0 in favor of continuing the public hearing till next month. Sorry to all those who showed up tonight, wanted to speak.
Should be the 11th, Tuesday,
Second
July
Tuesday.
11th.
Same time.
Second
So-
Tuesday of every month.
August 11th, you mean.
Sorry, what did I just say?
You just said July, so.
July.
yeah.
Sorry, we're past July 11th.
Yeah, I know.
August 11th, I'm sorry.
Maybe that date could go on the sign. I think it's supposed to be on the sign.
Yeah, I know it says public hearing. I'll ask my client if they can get out there and put something on there to that effect.
You're welcome.
Okay.
Thank you.
Those who couldn't speak because of another delay are unable to speak. We could have spoken to the specifics tonight, but there's also general comments that are pertinent, not specific, that I'd like to make. Is that possible?
Not at this time, because
Sorry, no.
they just continued
Yeah.
the meeting to
Well, I
next
gave
month.
up my time by not going to the general comments, assuming, because of your agenda, that I would be able to make both specific and general comments. The general comments are not addressing this, they're addressing planning in general. Do I have to forfeit my right to speak tonight?
Public hearings are not guaranteed. They can be moved at times. So public hearings are not always going to happen. Sometimes they can be delayed, deferred, or if the client
The
doesn't show.
general ones.
Yeah,
General ones are at the beginning of the meeting.
yeah,
Yeah.
If you're
Sorry.
speaking on something that is on the agenda, that would be during
Yeah.
public hearings.
And just to reiterate, Tim said, I know it's a bit annoying, but unfortunately, the way it asks is that if there, I know it's a bit stressed, but the way we do ask is that if you were to have it, that we ask you to split up the comments anyways. I know that can be a bit frustrating to do, but if there is anybody who is not able to come to the next meeting and have it, one of the things we do offer is you can submit emailed testimony to us.
Yeah.
We can have it written. I know that's a bit frustrating for it. I hope you understand for the decision for this to have to defer this.
Yeah.
But I know I've had people before who've said they can't make it. You can email us, and we can hopefully have that as part of the record for the public hearing.
It should be read in.
Yes.
Yeah.
Sorry, excuse me. It should be read in for as
Will
part
be
of the
read
public
in,
hearing.
yeah. Not a decision I wanted to make. I wanted you guys to talk tonight, but procedurally, we have to, and legally, we have to defer.
I should point out, it's not a decision the applicant wanted to have to pursue either. We were hoping to start and be done tonight, but it is what it is at this point.
okay.
Thank you, Paul.
Thank you.
So this next section Do we have any discussion, or is that gonna be tabled?
This is
Basically,
the
it's
same thing,
tabled.
so we kind of have to just table it, right?
Okay. Moving on. Got a lot of frustrated folks tonight.
And I'm assuming, have we
Rightly
gotten the
so.
subdivision regulation finished?
I'm still working on those, yeah.
Okay.
Okay, so no zoning referrals, no municipal referrals tonight. Old business, Gary, you're still working on the subdivision regulations.
Yeah, just to add to the list of things to add to our regs, I got contacted by the Postal Service. They're changing their policies regarding mailboxes. So all new subdivisions, what they're requiring, and you'll see over at the Twin Valley subdivision, and Farm Meadow will be, I think, affected, because just timing when they're getting built out, but they want, they're calling those boxes that have all the individual, I guess, the curbside, or they have a specific box unit, a postal box unit, I guess. Anyway, that's what they're requiring. Mainly it's because of theft and mail theft, you know, and lockable. It's also more efficient. I think it saves fuel and energy costs as well for the Postal Service, because they only have to go to one station, and it's all right there. So anyway, going forward, so I told them if they want to give us their criteria, I'd be happy to incorporate it into the regs. That's really, so we'll just we're adding that to the to-do list.
I would like to see if the new federal housing law will affect us. It doesn't seem like it, but it has more state level rules, it seems like, but that just came into, it didn't get vetoed, so it just became law as of like Friday.
I'm sorry.
That is the federal housing law. Yeah, I don't, like, based on it, I don't think it will affect us unless any of this stuff ends up being put by statute, that it's gonna be put down to the town level. It's mostly about purchasing of homes. So I don't think it will make too much of an impact, but I'm sure CCOG will have more information.
That is signed into law?
It didn't get officially subbed, because they didn't veto it, it becomes law. So it just officially became law, even though it wasn't. It's a little confusing, but it wasn't vetoed, so it's now law. Yeah.
Okay, let's finish this up. New business, none. Do I have a motion to adjourn?
So moved.
Second.
All right, vote. All in favor of adjourning?
Aye.
0. Meeting adjourned.